certificate of judgment, certificate of order against the government, serve it, then apply for the prerogative orders of mandamus. That will give the PS or the accounting officer a chance to come and explain why they are not honoring the judgment.
Yeah.
And if it is a question of a budgetary
I agree
issue,
with you entirely.
Thank you.
But please, we have limited time.
Oh.
The next question that I was going to ask you is that now you've explained very well why it is important to give those notices. What other dangers do you see that are fraught with courts declaring statutes or parts of the statutes to be unconstitutional?
I don't know whether I've gotten the question clearly.
What are the dangers? One, of course, you said you must give them notice so that you do not attach an ambulance.
All right.
Yeah.
So the reasons why you need to exercise some caution in declaring a statute unconstitutional is the laguna that is likely to obtain upon declaration of that statute as unconstitutional. What I've seen in most cases is that sometimes a court can give a structural interdict by giving the offending
okay, so one, you see that it's likely that there may be a gap or gaps in operations of government. Any other?
Now, the interest of the public again may be prejudiced if that statute is declared unconstitutional without basis, because
disruption of government functions and public services.
Yes.
All right.
And
finally,
public good.
And public good. Finally, the last one. Are we likely to be accused of judicial overreach?
Of course, there is that perception that in the manner in which we, as courts sometimes, because we are the custodian of this katiba, when the courts try to ensure that the rights of the citizens are realized, sometimes some sections of the society can see that the courts are overreaching, overstepping their mandate. But we have to be alive to the fact that this constitution captures the aspirations of the people of this country. And therefore, our duty is to protect and promote the values that are contained in this constitution.
Thank you, Judge. That's all from me, CJ.
Yes, good morning, Judge, again.
Good morning, Commissioner. AG.
Had you practiced criminal law before you joined the bench, or have you had occasion to attend to cases in the criminal division?
I practiced as a private practitioner. Usually, that is the common work that you begin with, particularly when you are beginning your practice. And I've also done criminal. I have practiced criminal law in the work that I do.
Yes.
Thank you.
Now, with the enhanced use of technology and development in technology, and also movement of people, where crime has become borderless, we find that most offenses that were created under the penal code were envisaged to be undertaken or committed in the physical world. However, now the crime scene has changed into the cyber world. Yet the penal code remains as it is. What are those traditional offenses that can be committed in the physical world and can also be committed in the cyber world?
Now, what comes to my mind are crimes to do with the property, like theft, somebody comes to your house and steals a goat, right? That is physical, or steals your sheep, or steals whatever physically, that property that belongs to you. But now, things have changed. People can now make use of technology to come and hit your account, hack your account without your knowledge. And so I think that is a sense in which the Cybercrimes Act was enacted to address some of these challenges that has come as a result of the technological advancement.
Thank you. Let's develop that a bit. The crime of theft. The crime of theft is defined under the Penal Code, and one of the conditions or precedent definition of theft is that you must have had an intention to permanently deprive the person of the property or asset. Permanent deprivation. Taking that into account, and having agreed that technology has influenced human life, we now have tangible assets. Do you understand the term tangible assets?
Yes.
Tangible assets are assets which are not physical.
Yes.
Can you give us a few examples of tangible assets? Of intangible assets, actually. Not tangible, intangible assets. Sorry.
I will look at it as in assets like you have property rights. Property rights in terms of what you hold, in terms of maybe shares, in terms of intellectual property rights, in terms of other things like that.
Thank you, you understand. So some of these intangible assets, some of them are purchased,
Yes.
some of them are created.
Yes.
Let us go to the ones which are purchased. Sometimes they can be limited, sometimes they can be unlimited. Supposing somebody steals intangible assets that is unlimited, and this person is charged with theft and is brought before you, how do we deal with the definition of theft that includes permanent deprivation? Taking into account that it might not necessarily happen within the borders of Kenya, it is borderless, and the time that it takes. How would a court respond?
I think my take would be that you need to have a purposive interpretation of theft to include some of those properties that are not tangible. That would be my take. If there is no law that addresses it directly, but if there is a law that has been enacted that addresses that issue, then you look at the definition therein.
So do you think there is a need for us to look at our criminal laws to take into account some of these assets, procedures, and ways of committing crime that are emerging with the use of technology?
That is exactly, you have captured it exactly. Law should actually be dynamic because people keep on changing. What was obtaining 20 years ago, right now, it's totally different.
And would you be able to appreciate the need to capacitate law enforcement agencies and the need of the judiciary and the appellate courts to appreciate the challenges law enforcement would face, taking into account what we've talked about?
Exactly. We need to continue to build the capacity of both law enforcers and even the courts. And I think that is the reasons. That is the reasons why there is continuous legal education that is being undertaken at the Kenya Judiciary Academy under the directions of this commission. And I think you are doing a commendable job, ensuring that the judges are brought up to speed in terms of training. Recently, I attended a training on counter-terrorism and what the criminals, the criminals underworld are now using to commit crime. And I can assure you it was actually a mind opener. I had no idea of how these people can actually work. But after that training, I'm now able to, if a case is now brought before me, I will be able to understand the intricacies that is involved in the underworld or in the internet.
Appreciate that. Now that you attended a counter-terrorism course, maybe you could tell us, why do we normally say that terrorism, the offenses with regard to terrorism and terrorism financing are preemptive?
Are you talking about the preemptive action or that?
We have offenses like murder, which is after the fact.
Yes.
Most offenses created in relation to terrorism, counter-terrorism, terrorism, and terrorism financing are preemptive. Meaning that they don't have to be completed to prove an offense.
Of course, because the intention alone, you look at the intention to cause a huge harm to the public, you know, and when you look at the harm that is likely to be caused, that is why now you look at into that preemptive action to ensure that that action, that preemptive action is taken as an offense, is defined as an offense, so that it is the country is able to deal with the threat before it actually can be actualized, like what it happened in Nairobi a few decades ago.
Thank you, and I appreciate your answers.
Thank you.
Thank you, Judge. Before I go to my questions, I just want to follow up from what the Attorney General has asked. And I heard you say that you can give a purposive interpretation of the law to cover up for a lacuna in criminal law. Won't that be replacing your judgment in place of Parliament? If there is no law, then there is no law in criminal law. Can a judge replace his views?
A judge cannot enact a law,
yes,
because of the doctrine of separation of powers.
Yes.
But you are talking of a situation,
yes,
where an offense has been committed.
Yes.
And that offense is theft. And the way it was defined decades ago,
yes,
as kind of lost track.
Yes.
You know?
Yes.
And so for it to gain track, you have to give that definition,
yes,
a purposive interpretation for it to cover the theft that can actually be done. You see, the end result or the end product is theft. Somebody depriving you permanently of what you own, what you have worked for, your hard hand cash or income or asset. But that is how I will look at it.
Okay, but if it does not exist, it just doesn't exist.
It doesn't exist.
So then why would you replace your values or because for instance, from my recollection, corruption was not defined as an offense up to around early 2000. So before then it was not there. So would a judge create such an offense through interpretation of the law?
No.
Okay.
Yeah.
All right. Now, this court that you aspire to go to, the Court of Appeal, does it have original jurisdiction to declare a statute unconstitutional?
It doesn't have original jurisdiction under the Appellate Jurisdiction Act.
Yes.
I think Section 3.
Yes.
The jurisdiction of the COA is limited to appeals that emanate from the High Court and courts of equal status and also tribunals.
Okay.
So unless that question of declaring a statute has been a subject of adjudication in the High Court, the Court of Appeal wouldn't be able to go into it. I think there's a decision of the Supreme Court in that regard.
Yes. Now, coming to that decision of the Supreme Court, if it is a decision that has been made with respect to a statute, say by one of the superior courts, and then it is concluded and it comes up to the Court of Appeal, would you have power as an appellate court to say that to correct the superior court and say, you got it wrong here, the correct interpretation was to declare this statute unconstitutional?
Yes.
Or do you send it back to the trial court?
No. If the issue of unconstitutionality
Yes.
has been the subject of litigation,
Yes.
and the High Court has rendered itself,
Yes.
then the Court of Appeal is well placed now to make a finding, to evaluate the reasoning behind declaration of that statute as unconstitutional, and maybe give a finding whether the decision is correct or incorrect.
Okay. Actually, the decision you're talking about, I think, is Albert Mumba versus Morris Mnyao.
Yes.
A decision of that came through the ELRC, then came to the Court of Appeal, and then the Court of Appeal found that the ELRC did not have jurisdiction. Then now the matter proceeded to the Supreme Court. But then the Supreme Court sent it back to the Court of Appeal to determine the issue of unconstitutionality. Now, are there cases whereby the courts where you have competing claims with respect to a subject matter, a court can have an optional jurisdiction? For instance, it's with respect to pension. Pension is somewhat connected to employment.
Yes.
You have a matter that comes before say the ELRC. Would in that case that court have power to determine that dispute?
Yeah, thank you for that question. I think I get you clearly. I think it speaks of the jurisdiction of a ELRC court.
Yes.
And I think the jurisdiction of an ELRC court under Article 162 is limited by statute and also by the Constitution to issues related to employer-employee relationship, labor disputes between a worker and the employer.
Yes.
So issues to do, I think there's a decision.
Yes. So I just wanted to pick your mind.
Yeah.
In that case, what would that court have?
So the court would have jurisdiction.
Yes.
To determine disputes between employee and employer.
Yes.
As per section 12.
Yes, of the
But
Employment
now,
Act.
if it is between the employer and other body like pension,
Yes.
and the challenge is on the law
Yes.
regulating that relationship,
Yes.
I think it is outside the ambit
Of
the employer-employee
relationship.
that will then bring it within the scope of the ELRC jurisdiction.
Okay.
So
So
it
what is
will-
the test?
So it will have to be determined by the High Court under 165.
Okay. That's correct. And lastly, I wanted to ask whether the act of adverse possession can be taken to be unconstitutional for depriving an owner of their property.
Again, I think that is a principle of law that if someone has been in a possession of a parcel of land for a continuous period of 12 years without the owner coming in,
Yes.
when the ownership or the use and utility is adverse to that of the owner and he doesn't say anything, then probably there is a good reason why that owner has no interest in that property. And so there is no way I can declare the issue of adverse possession unconstitutional because of those factors.
Okay.
Thank you.
Thank you, Chief Justice.
Thank you so much, Honorable CG. And Judge, just within the employment law,
Yes.
which Commissioner Omwanza took you through, one of the remedies which an ELRC court can grant is the remedy of reinstatement of an employee. What could be some of the considerations taken into account by a court before making that order?
Before a court grants a remedy of reinstatement, it should be a very exceptional remedy in the first place. I think it is it Section 40 of the Employment Act or Section 49? I'm not so clear about that, but it is around, I think, Section 40. It talks of practicability of that remedy. You ask yourself whether reinstating this individual, if, of course, the other aspects has been proven that the sacking or termination of employment was blatantly unlawful. There was procedural impropriety in the sacking and other issues. And so before you give that remedy of reinstatement, you have to look at the practicability. How long has that employee been out of employment? If, for example, he has been out of employment for more than 6 years, example, you realize that perhaps even reinstating that employee might be moot because already the position might have been taken. And I have, I'm looking at it from the view that if this employee was a CEO or executive officer of that company, for example, how practical will that remedy of reinstatement would be to that company? Because when that employee reaches the office, he will find there is another replacement. And so it becomes a bit impractical. And so before you order for reinstatement, you have to look at whether the issue of compensation can really gather for that remedy, or salary in lieu of notice,
Okay.
and other damages that can remedy the situation.
We can hold it at that indeed. You're right. And let me take you back to the document which you have stated that your duty is to ensure that you protect it and you implement it.
Yes.
That is the Constitution. And I want us to take a walk to Article 24. Article 24 is on limitation. And when you are considering whether a right or fundamental freedom is properly limited, there are some considerations which a court must take into account.
Yeah.
Could you name them maybe?
Yes. Before, again, there is reasons why sometimes there is need to limit some of the rights under the Constitution, the human rights, the fundamental rights. That's why that article is there. But before you limit those rights, you have to look at the extent of the limit, the purpose, the reason, the rationality aspect of limiting that right. And before you go to the limit, you look at whether there is another way of realizing the objective without limiting those rights. But you look at the purpose. For example, if there is a right to religion, right? Your right to worship in the manner in which somebody wants to worship. And so if part of the worship includes singing in loud voices and using equipment that are likely to infringe on the rights of the others. There is a reason why sometimes a law is enacted perhaps through NEMA to come and limit that noise, in the sense that you create a room like this room where we are in and ensure that it is soundproof, so that you realize the objective of not being infringing on the rights of the others to also enjoy their fundamental rights. And that's what I mean by looking at other avenues whereby you don't have to limit the right, but look at the public interest. And of course, the limitation also has to look at Article 25, because there are rights that are non-derogatory, like the right to fair trial, right not to be subjected to inhuman or degrading treatment. Those are non-derogatory rights.
Okay, thank you.
Thank you.
Honorable CJ, that's all. Thank you.
Thank you, Judge. I noticed from your application, apart from saying that you hold a Master's of an MA in Governance and Ethics, you also have covered several courses which include corruption and anti-corruption measures, ethics and accountability. Do I presume that this is still an area of interest for you?
Commissioner, that is the reason why I joined the judiciary.
Okay. So
I joined it for that one singular purpose.
Therefore,
Yes.
are you able then to give me an example of any Supreme Court decision that has touched on the investigation and or prosecution of corruption-related cases? We have several. We have several in the Supreme Court. If you can just mention one or two, and the legal principles which we settled. Thank you.
It's a bit hard. That's a hard one. I can recall. Yes.
Recently, we settled the law on recovery of unexplained assets.
Yes.
Yes. Do you remember that matter?
Yes, yes, yes.
And what was it about, and what did we have to say?
I think the court overturned the decision of the Court of Appeal, and I think remitted back the matter for trial. And what the court said was that where somebody has explained assets and the prosecutor has established that fact, the burden should actually be on that person to explain how these assets came into his possession. And I think that's a good principle, because unless the burden is shifted to the person who has accumulated unexplained assets, then the war on corruption will be lost.
Thank you for that. What if you are hypothetically presiding over a matter in which the DPP has charged an accused person with a corruption offense, and that accused person raises a preliminary issue pleading a constitutional case and asking the court, asking you to decline to proceed with the corruption case, but to make a finding on the constitutionality of the process, and therefore determine the case once and for all. What would your response be, given a number of decisions made by the Supreme Court?
Thank you, my lady, for that question. My take would be to let the legal process take its course, so that the court that is seized with the jurisdiction to determine the issue on merit can have that chance to determine the issue, whether or not there's corruption or there's misappropriation of public funds. So there is a court that is seized, which is a criminal court, that is seized with the jurisdiction to determine whether or not the person is guilty or not. But these other issues of circumventing the criminal process to kind of use it as a shield should be avoided. I believe that is what the Supreme Court has stated in principle.
That is correct. Thank you.
Thank you, my lady.
Thank you, Chair. Good morning once again, Judge.
Good morning, Commissioner.
I've gone through your sample writings. You shared different types of judgments and rulings that you have prepared. You demonstrate clear issue identification. You are coherent. They are well reasoned, and you are consistent when it comes to application of constitutional, statutory, and common law principles, and you also apply relevant decisions and comparative jurisprudence well. You use measured and impartial professional tone, and from your sample writing, you appear to incline to the purposive interpretation of the Constitution. So I commend you for a good job.
Thank you, Commissioner.
I also note that most of the decisions that you've shared are not very current, 2021 and the likes. So you may need to explain to us why you felt it was wise to share not very recent. The second question is there is the defamation appeal matter, where you appear to have used the purple prose language, and allow me to read part of how you begin with that judgment. Uchawi is real is a street mantra that seems to have found traction in this matter, particularly given that we are in Kitui, a renowned place in matters witchcraft. How else would you explain a matter involving witchcraft finding its way to the appellate court? So when you start your judgment like that and say Kitui is a renowned place on matters witchcraft, is it a perception or is it factual? And what would the residents of Kitui feel about this particular finding? And then the second question, you declined to invalidate the trial court proceedings on account that the advocate lacked a valid practice certificate. And I like that you are able to carefully apply the Advocates Act and Article 159 of the Constitution, and you held that professional non-compliance attracts disciplinary consequences and not nullification of proceedings to the detriment of access to justice. If the pleadings and the proceedings were conducted by a quack or a person not authorized to practice law, would you still have held what would your conclusion be the same?
Let me start with the Kitui.
Yes.
I'm lucky though I've worked in that station. Before I went to Kitui, of course, you know what is happening in the country. You know, we are living in this country. And when you walk even in the streets, you kind of find those boards that is put in very high, in the trees, you know, signboard saying, Daktari wa mashuhuri.
Kutoka Kitui.
Kutoka Kitui. Anatibu
Kila kitu.
shida ya wanaume.
Kushinda kesi.
Yes, and many others. And so it's almost in everywhere you go in this country, you will find that. And so even before I went there, I was being asked by my colleagues and even family, are you going to survive there with all these witchcraft? Of course. And so I think it's a matter that can, I was just taking judicial notice of a fact that is of general public knowledge.
So what would the residents of Kitui say? There are those who will say it's not factual.
But it's
So
not
we
factual,
put
but
it as
they
such.
know. If you and they are even proud. They are even proud of the fact that they can actually make you return a goat if you have stolen the goat, because it is believed that the peace will come and land on your head.
Okay. I see Commissioner Zilani smiling about that. I don't know whether she's happy or she's angry, but I'll leave it at that. So maybe you could kindly respond to the second question.
So that's why I actually began like that, you know. You see, sometimes my philosophy is anchored on realism. That is, you need to be aware of where you are and deliver justice that is meaningful to the people that you are serving.
No, but what I'm just trying to say, Judge, is that maybe people of Kitui, some of them would not be okay with that generalization.
All right,
but you can still go back to the
maybe
second.
a small fraction,
Okay.
but they all know what their specialty is in that area.
Maybe we can leave it at that.
Yes, thank you.
Before you
Now,
continue making them angry.
okay.
So we can go to the second bit of the question.
Now, that's about the lack of practicing certificate. You see, an advocate actually, when they are appearing before a court, they are actually standing on the shoes of the litigant. The case is not theirs. The cause is not theirs. It belongs to the litigant. And that's the sense in which I found that if a person files documents without qualification or without the competency to file those documents, it will be injurious or quite unfair to a litigant who has paid so much money to access justice, to be just informed that, look, the person that came to court was unqualified, and therefore all your documents, including your case, is struck out. It is better to when it comes to your knowledge that the person is unqualified, it is good to tell the litigant, now your pleadings are in court, but look for a competent, qualified advocate to come and argue the case on your behalf, so that you don't infringe on his right to access justice just because of a mistake of a person, which mistake the litigant may not have known or may not have come to his knowledge.
I do agree with your findings, Judge, which you say it's a disciplinary issue, not an access to justice issue, but I just needed to find out if you established that the pleadings were drafted by a quack, a person who is not an advocate at all, and was masquerading in court as an advocate, would you still have gotten to the same conclusion?
I would still get to the same conclusion. Yes.
Thank you and all the best.
Thank you.
Chair.
Thank you, Chair. Good morning once again, Judge.
Good morning, Commissioner.
Yes, in your earlier introductory remarks,
yes,
you were about to embark on telling us about your achievements, but
yes,
you were cut short because that was not the time. And I don't want to deny you a moment to shine.
All right.
So
Thank
maybe
you.
I can give you just a few minutes of
All
the
right.
questions, the type I was supposed to engage you,
All right.
to just highlight some of your achievements.
Yeah. It is actually related to issues of integrity and what I have done in my sojourn in judiciary to address the issue. Before I joined the judiciary, when I was given the responsibility of leadership in the LSK North Rift region, I dealt with so many issues of integrity against judicial officers and even judges. And what I used to do is, wherever I get information that I felt were well-grounded, I would actually walk into the chambers of these judicial officers and judges and tell them that this is the reports out there. These are the claims that you are taking bribes or you are being influenced, corrupted. Therefore, I don't know the veracity of it, but please know out there that this is actually happening. So, unless you stop, then we, of course, as a LSK, we are going to take action. And I can assure you, of course, I rubbed shoulders with some of them the wrong way. Some were able to stop the habit. Some just took off and went on transfers. But I was very forthright, because this thing, unless you are forthright and brave, it is very difficult to deal with it. The other issue is that, of course, you have to also to be very fair in your approach and ensure that you don't act on rumors, because there could be so many rumors out there. So when I went to Kitui, it was very dramatic. I reported there a few days after an event had taken place. The event was, there was a matter involving a plea on a person who was suspected to have been having elephant tusks. And you know, wildlife trophies, dealing with wildlife trophies attracts very heavy sanction. And so this person, I'm told, was taken to court, took the plea, pleaded guilty, was fined around, I think, 1.5 or 2 million. And he screamed in court at the top of his voice, asking the presiding magistrate why he had fined him that much when he had already complied with what he had been told to comply. So because of the screaming, of course, the magistrate did not know what was actually happening. So he went inside the chamber, called the prosecutor, and asked him to go and find out why the screaming. So the prosecutor went, inquired from the fellow, and the fellow in the cells told him, I had paid some money, 100,000, so that I could be freed. So the magistrate called for the person who had done it, who interrogated him, and he agreed that indeed he had taken the money. So what did the magistrate do? He told the fellow to refund the money. So the fellow refunded the money, but then beat him up in the cells for exposing him. Quote, of course, exposing in court. And so, I mean, after refunding the money, of course, that is how the matter ended. And so when I reached there, I was told that is actually what happened. Then I asked the presiding magistrate, so this guy has been beaten. This is a person who is doing this. What have you done? He told me, this one is untouchable. He actually called the court administrator and told me, this one, this clerk has been here for more than 25 years and cannot be touched. The administrator told me, Judge, if you touch this one, you will walk naked. Please, leave this one. So, what does he do? He decides, please, which court the plea would go. So, unfortunately, that time, I think he made a mistake. Instead of going to a court that he had done the needful, it went to a different court. So the magistrate actually had no idea, you know. So he said, you mean you cannot touch this because I will walk naked? Okay, I told them, okay. I took my phone, and then I called the Honorable CJ. I told him that you have sent me to Kitui, but there's no way I will serve here and deliver justice when down there it is as rotten as it is. The CJ Emeritus asked me for evidence. I told him, CJ, I've just reported. This is the situation on the ground. I cannot work. So he told me to do a write-up. And I, of course, told the magistrate who was presiding over to do the write-up. And the long and short of the story is that the fellow was transferred. And I did not work naked. And that is how I gained a lot of confidence and teamwork in Kitui, and was able to bring that practice to an end.
Okay, I may need to cut you short. I'm sure you have many more other
Very many,
instances of
very many,
achievement.
very many.
But at
Commissioner.
least the Kitui story, there was impact of your being there.
Yes.
And we'll take it at that.
Yes, even Kitale, there are many other stories too. And,
Okay.
Yes.
Okay, maybe to briefly to address something else. We know the judiciary performance framework.
Yes.
And the system and how we go about evaluating performance. It majorly focuses on numbers.
Yes.
So there's always been the question of the qualitative aspect. Last year, I believe, no, last year but one, we were at an IMJA conference and discussions came up around evaluating the quality of decisions that judges or judicial officers make in also evaluating performance and making that system qualitative. What's your take on that? Proposals were up and, were being put up that we should look at how many times, for example, judges' decisions are overturned on appeal or a magistrate's decision are overturned on appeal to determine their performance when it comes to the qualitative aspect. What's your take on that?
I believe that my take is that that tool for measuring the qualitative aspect of the work that judicial officers and judges do is important. But the quantitative aspect is also important because we are dealing with backlog, which is a perennial problem in the judiciary. So you cannot just look at the qualitative aspect without looking at the quantitative aspect, because the overall objective of evaluation and PMMU is to make our administration of justice efficient from the time the cases are filed to the time it is determined to the time the execution process takes place. And so both aspects, qualitative and quantitative, are as important. And so you cannot say, let's just have qualitative aspect. I agree that sometimes some of the cases that come before us are heavier than the others. Mm-hmm. Yeah, and so it needs also, that aspect also needs to be looked at. But it cannot be looked at in isolation. Because you cannot just tell me that because you have decided two very heavy duty cases, you are as good as a person who has determined and finalized 200 cases in a month.
I agree with you on that. But what I was looking at is a scenario where we look at the number of times your decisions are not upheld on appeal to determine whether or not you are a good judge or a good judicial officer and you're performing. Mm-hmm. What is your take on that?
It is important. It is important to use that as a tool as well, because then it also touches on the competency and also how good you are as a judicial officer or a judge. If 50% of your matters are overturned, then you need to have a self-introspect, a reflection. But if 99.9% of your decisions are upheld, I think you need to give yourselves accolades if nobody is giving you any.
Okay, thank you, and I wish you well.
Thank you.
Okay, thank you, Honorable Chair. Judge, welcome again.
Thank you.
Now, what is your stance on separation of powers, and how would you navigate potential conflicts of power struggles between the judiciary, the executives, and the legislature?
Yeah, the separation of powers doctrine is a doctrine that respects various arms of government in their roles as prescribed in the Constitution and the statute. And so there should be respect of, in terms of giving room to all these arms to function, because these organs of government are meant to serve the people of this country. And so they have to work within the limits or the extent to which the prescription gives. So if the Constitution gives them the functions of, or their function or how they can exercise the authority, they have to act within the scope of that limit. And if there is overstep, then I think the court is given the constitutional mandate to provide checks by telling them that, hey, you have gone beyond what the law says. So that's how I will navigate the separation of powers issue and the conflict that can arise, by ensuring that each person, each organ sticks to its lane as prescribed by the Constitution and the law.
Okay. And now, how will you balance judicial independence with accountability in governance?
That's a good question, Commissioner. Judicial independence is a good virtue, because then it will give confidence to the people who approach you for solving, for dispute resolution. In going about resolving those issues, you need to exercise some judicial independence. But that does not preclude you from the accountability aspect, because it's also a constitutional imperative that you must be accountable to the people who gave you the mandate, because you're exercising a delegated power under Article 159. So you need to be accountable. You need to be transparent. You need to be able to act as expected, act to the expectation and the aspirations of the people who gave you that power. So you cannot hide behind independence and to act with impunity. There's no room in that, in this constitution.
Mm-hmm. So how will you be accountable to the public?
You have to be accountable in the sense that I think
Are there mechanisms?
There are mechanisms, because at the end of every year, I think the judiciary gives their annual reports regarding what the judiciary has done to not just the funds that they have been given, but to the roles that they have been given and how far they have gone ahead to achieve the expectations of the people of this country. Mm-hmm. Yeah. So individually, you have to be accountable to what you do. Like now, when it comes to those performance measurement imperatives, that is one aspect of accountability. You are accounting for what the people have given you. So you have to show that this is what I have done. You have sent me here. This is the work that I have done, and I have done it to this extent. I have dispensed justice because that is the work that you have been given under Article 159. But in doing that, you have to also have in mind that there are constitutional imperatives under Article 10 and also, I think, 232.
Okay. Thank you, Chair. Thank you, Honorable CJ. Judge, let me begin by saying the issue of Kitui being a renowned place of witchcraft is a stereotype, because it's disputable, and I think you've generalized the community. But we move on with the interview.
I'm sorry for that. I hope I'm not going to suffer because of that general knowledge.
We move on with the interview, Judge.
Thank you.
What is your understanding of emotional intelligence? And maybe you can tell this commission a situation where you have used emotional intelligence to communicate effectively in conflict resolution.
Now, as a judge, when you are conducting trials, many people come to your court. Some of them are quite hurted because of what happened to them. For example, if you are conducting a murder trial and a victim or a family of a victim comes to testify, on how they lost their loved ones. So at times, you need to show empathy to this person who is appearing before you. Sometimes they can even break down and cry. So when such things happen, it has happened in many instances in my court. I give them time to cool down. I even tell them I even give them permission. If they were standing, I give them permission to sit down. I get somebody to maybe stand with them, give them a glass of water to relax, and tell them that, look, we are sensitive to what happened to you, and even request the advocate not to push that witness to things that are really emotionally draining. So that's how you deal with. Another aspect of dealing with emotional intelligence is also dealing with the staff, members of staff. Some of them come to work sometimes. They have personal issues. You see a staffer is not able even to work with you because of the problems that they could be having. So the best way of dealing with such people is to understand. Trying to understand them so that you are able to be effective as a judge. Because you are not living in an island. You are living with the people.
Okay. Thank you. How do you handle the issue of alcoholism in the workplace?
First thing you do is perhaps to just talk to this staffer or officer and find out the reasons why they are perpetually coming to court. Some of them come to court drunk, by the way. And I've dealt with some of them. I have spoken with some of them. Some of them have reformed, some of them did not. And I communicated to the CRJ to take them to a rehab for rehabilitation. 2 of them were taken in stations that I've served. 1 actually recovered, 1 did not. I left the station when I was still dealing with the issue. Okay. So alcoholism is real in our stations. It is real, not just in the judiciary, but I think it is across the board. And
So
we have to
how
look.
would
Yes.
How would you still process or deal with the one that did not recover because they're still in the station?
Now, I'm telling you, I left that station, and so the person who came to take over from me, I'm sure is doing a good job. Maybe even she has even succeeded. I do not know.
Maybe I need to rephrase. If you were still there and this person is still under your watch,
If I
what
was,
would you do?
I would maybe send the person back to rehabilitation, and if he cannot rehabilitate, then in the public interest, then perhaps I will recommend that action be taken. Because at the end of the day, members of the public, the consumers of justice, must be served with sober-minded people who are able to deliver.
Okay,
Yes.
fair enough. My final question, how do you handle negative feedback and criticism?
You have to handle them very objectively. Don't take offense. If a negative report comes, look at it from an objective point of view. Carry out the investigations, because sometimes some of these views are actually true. But if you just hide under the cover that these are generalized issues or they could be malicious, sometimes you may not solve a problem. But if you take your time to investigate, perhaps even call the court users committee and raise the issue so that it doesn't become personal, the issue will be addressed in a good way.
Okay.
Yes.
Thank you, Judge, and I wish you the very best.
Thank you.
Thank you very much, Judge. Of course, I'll keep off Kitui for now.
Thank you. Thank you, Commissioner.
Yes. Now, what do you consider the most pressing global challenges today? And how do they affect national institutions such as the judiciary or public service?
There are quite a number. I'll look at it from the perspective or unemployment, particularly the unemployment of the youth, the social issues that comes as a result of that unemployment. the other aspect is, of course, because of that unemployment, you find that most youths and the population in general indulge in antisocial activities that sometimes invariably ends up in court. And so sometimes you need to address some of those issues with that problem in mind, that it is a global issue. The other issue is the issue of misuse of the social media. I think it is a problematic issue, not just in Kenya, but it's also a global issue where people misuse social media to either bully or even abuse other people, you know. So it's a big problem that sometimes even ends up in court.
How should international developments such as, let's say, in your view, how should national institutions balance sovereignty with international obligations?
Yes, thank you, Commissioner. That's a good question. That question brings to mind a matter that I dealt with. It was a question of a dispute between Kenya and Somalia over the maritime boundary between the two countries. The matter was a 3-judge bench, and the way we dealt with the issue, first of all, was that the issue was a political question that we needed to exercise some judicial restraint, because the people who were better placed to deal with it was actually the executive, because of the treaties that they have signed. And so, to deal with that issue, you need to look at the treaties that you have signed with the international bodies like the ICC and the ICJ and the likes. So those treaties are actually issues that should be implemented, not by the judiciary, but by the executive.
Okay, thank you.
Thank you very much, everybody. I think this brings us to the end of the interview on our part. Judge, we always give a candidate an opportunity also to engage with the commissioners if there is anything you want to tell us. The floor is yours.
Thank you, Honorable CJ, for this opportunity. I want to thank this commission for affording me this opportunity to appear here for this interview. That in itself shows that you had confidence that whatever I'm doing is fit enough for me to be shortlisted for this interview. And I do not take it for granted. And I really wish to thank you, because even coming here alone has meant that I needed to have a relook at what I studied many years ago. And so I've gone through some of the notes and even decisions from the Supreme Court and the Court of Appeal and other decisions. And it has kind of opened my mind in many things that I do not think would have happened had you not invited me for this interview. So it has been very productive for me, and I wish to thank you. And I also wish to pray to God to give you energy, because sincerely speaking, I know you really need a lot of energy to conduct these interviews, but you are doing it for the best interests of this country. Thank you.
Thank you very much. We also want to thank you for the work you're doing for this country, for the judiciary, and to hear that even this process has added value to you because you took time to sharpen your skills to come here. Yes. We appreciate that.
Yes.
So we will get in touch with you when we complete the process. Right now is to wish you all the best and send my greetings to the people of Kitale. I worked there.
Yes.
And it's a good station.
Thank you.
Yeah.
Thank you so much.
Yeah.